Evening, everyone. To the Planning Application Committee meeting, 10th of June, at the Civic Centre. Everyone in the meeting and also those observing the meeting on Microsoft Teams. Fire alarm procedure. There are no fire drills expected this evening, so in the event of an alarm sounding, please quickly make your way out of the building. 3 exits from this room which members can use to vacate the premises. Please switch mobile phones onto silent or switch off. Take any calls received outside the meeting room. Not leave any bags unaccompanied. Report any unaccompanied bags. Remember to take any bags with you when you leave the meeting. Meeting is concluded. This meeting may be subject to filming or audio recording by others in accordance with Council's protocol. Anyone who remains in the meeting following this announcement deemed to have consented to have their image to be recorded. Item 1 on the agenda, apologies for absence. Have substitutes. Declarations of interest. Are there any declarations of interest? I have one. Item 8. Respective application for 103 Sherwood Street. I know the applicant also supply the chip shop eyes have done so financial association. So I'm declaring it, and I will leave the meeting at that appropriate time. Chair to step in. Item 3 is the appointment of the Vice Chair. I'd like to propose Councillor Hammersley as Vice Chair. Do you have a seconder? Are there any other nominations? No. Thank you. Councillor Hammersley, you're elected Vice Chair. I advise we still need to have a show of hands even though it was unopposed, so have a show of hands on that. Charles, do you want to say something? Charles. Item 4, minutes of the meeting held on the 13th of May. Have a proposer. You, Councillor Bell. Stevenson. True record. Yep. On to item 5. Planning application 24013. Application for a lawful planning change of use of existing dwellings. See children's home. 1 number child 2 on the office to for your report. Been issues with the microphone here. Got two speakers on this application. I'd like to invite James Stannard to the podium. You ready? If you put the mic on, you've got 4 minutes. Okay, James, thank you.
Yep. Good evening, councillors. The application before you is seeking a certificate of lawful development on the basis that the proposed change of 21 Open Close Mansfield to a children's care home for one child does not require planning permission, as it does not amount to a material change of use. Councillors will be aware that the assessment as to whether the certificate can be granted simply comes down to the question of whether planning permission is required or not, as a matter of planning judgment. This judgment is based on the individual facts of the case, having regards to legal precedents held in relevant case law, and how this precedent has been applied by the council and planning inspectors in similar instances. Any objections or concerns which have been raised by members of the public regarding the merits and potential impacts of the proposed use, which include, amongst other things, the desirability of living next door to children with complex needs and the potential for antisocial behaviour, cannot and should not be taken into account. Officers have concluded within the report that 1, the existing property has the characteristics and relationship with the neighbouring properties that are typical of a medium density suburban neighbourhood. 2, no physical external changes or alterations to the property are proposed, and thus the character and appearance of the property would not change as a result. 3, the vehicle movements associated with the proposed use would be very limited and would not be materially different to what would be expected of a typical 4-bedroom dwelling house. 4, the proposed care home for one child would not lead to a significant increase in noise and disturbance that would be unacceptable in an established residential area and would give rise to a materially different level of activity than the existing use. And 5, that based on the evidence put forward within the application, that when considering the facts of the case, the proposed use would not be material, and thus the proposed change of use does not require planning permission and is therefore lawful. Given the fact that this application amounts to a planning judgment as to whether planning permission is simply required or not, we would respectfully ask that members to heed the advice of officers and, in line with officer recommendation, grant the certificate. Thank you very much. Just to say, the applicant here today can answer any questions specifically with regards to the detail of the proposed use. The second speaker. Thank you.
Thank you, James. Do members have any questions of this speaker? No. Okay. I'll invite the applicant, David Price. Again, David, when you're ready, if you put your mic on, you've got 4 minutes. Thank you.
It was actually just to field any questions from this perspective. James has presented just from a planning perspective.
Thank you. Do members have any questions of the applicant? Yes, Councillor Moxon.
Yeah, I just wondered, have you consulted with any of the neighbours or during doing this application?
Yes, we have.
Elaborate on what they might have said, or?
We held a public consultation. Again, it's registered our. Yeah, was it last week we held.
Members have any further questions of the applicant? No. Thank you. David. Do members have any questions of the officers? Councillor Hammersley. there any further questions of the officer? Councillor Answer.
Chairman, just a comment. It was said that we don't need the certificate. Child is child being. I've given them a certificate to say that's the case. To open the door for just in that application further down the line to open the door as part of that.
No, it doesn't, because the certificate restricts it to, well, the proposed use to one child. So that is that is all that's allowed by the proposed use. If that wanted to be changed, then that will be subject to a further planning application or further certificate. But the certificate is issued based on those facts. It will be one child.
Are there any further questions? No. Could I ask for a proposer and seconder to issue the certificate? Proposed by Councillor Stevenson, seconded by Councillor Tempest Mitchell. We're now in debate mode. Anyone want to comment? Councillor Moxon.
Yeah, I just wanted to acknowledge, thanks to the developer for that have been listening to my rants at previous meetings where they've actually met with the residents. I think that's great. That's exactly, as far as I'm concerned, what they should do. So you know, by the sounds of it, they've done the right thing. Happy to know where this house is, and it's in a location. It's probably in one of the better locations, as in it's the end of a cul-de-sac, and it's all quite secure and everything like that. So I've got no qualms with it at all, but you know, sort of, but well done to the developer for engaging with the local community.
Councillor Moxon. Yeah, this mic's not great. Any other comments? No? Right. Could I go to the vote by show of hands then? All those in favour of issuing the certificate, please show. Any abstentions? Any against? Motion's carried then. Planning application 2024-0136 CLPD. Application for lawful development certificate under the Town and Country Planning Act, England, Order 2015. Change of use of existing dwelling house C3 to a children's home for one number child C2. 21 Opal Close, Mansfield, has been granted. Committee. Move on to agenda item 6, which is planning application reference 2024-0166 full change of use from a 3-bedroomed residential dwelling use class C3 to a children's care home, one number vulnerable child C2. It's 54 Little Barn Lane, Mansfield. I invite the officer to make a report, please. Thank you for the report. I'd like to invite James Stannard to the podium again. And this will be similar to last time. Turn your mic on, James, and you've got 4 minutes. Thank you.
I'll just start by explaining. I think the gentleman wanted to know why we've gone for an application rather than a certificate, and it's purely based on client instruction. So when you're looking at this kind of proposal, there is a judgment call as to whether something requires planning permission or not, and where there's a bit of a grey area, it's always safer if something's acceptable in principle, like here, to go for full planning permission where there's more flexibility to consider something rather than a black and white answer of does it require planning permission or not. So that's basically why we did that. So this application obviously seeks a full change of use from the same C3 to C2 for a single child. As set out within the submission, there is a chronic under-provision of social care for children, both regionally and nationally. The proposal is fully supported by Policy 86 of the local plan and relevant paragraphs within chapters 5 and 8 of the NPPF, which together support the provision of housing for all members of the community within the urban area. The principle of the proposed use is obviously therefore acceptable. The two planning issues need to be considered associated with this application are: one, the potential impacts on the immediacy of residents in the surrounding area, and two, highway safety. So with regards to the former, objections have been received that raise concerns regarding noise disturbance, potential increase in crime and damage to properties, impact on health and well-being of neighbourly elderly residents. In response to these concerns, the care home operator has a number of detailed policies and procedures within their statements of purpose, which was accompanying the application, designed to ensure that a family-friendly environment is provided for the child to minimise disruptive behaviour. We fully concur with the officer analysis within the report that makes clear that the possible behaviour of individual children is not a material planning consideration, and that the behaviour of such individuals cannot be prejudged, predetermined or stereotyped. We draw members' attention to the fact that the Environmental Health Officer and the police have both reviewed the submission and both have confirmed there are no objections to the proposal. As such, we submit that there are no substantive grounds to refuse the application on grounds of amenity, and that the application is fully compliant with Policy P7 of the local plan and relevant paragraphs within the NPPF. Turning to matters of highway safety, the site contains sufficient parking provision for 2 cars, which is commensurate with the number of staff that will be on site at any one time. Highways did state their desire for 3 parking spaces, but officers were of the opinion that that third parking space, in line with what we were saying, is not necessary, and that occasional individual visitors can and will take advantage of unrestricted on-street parking nearby. The vehicle movements associated with the proposed use have been considered in detail and are likely to be lower than that associated with the existing dwelling house. As such, the application does not result in any adverse harm to highway safety in accordance with policies IN9 and IN10 of the local plan and paragraphs within chapter 9 of the NPPF. In summary, the principle of development is acceptable, and officers have concluded that the proposed use would not give rise to any adverse harm to amenity or highway safety, and thus complies with all relevant local and national planning policy. The application thus constitutes a sustainable form of development, and we urge members to uphold officer recommendation and approve the application. Thank you. I'm happy to answer any questions that I can, and if I can't, then the applicant will. Thank you.
Right. Do members have any questions? James? No indications? Thank you. Invite the applicant David Price to the stand again. Do you want to speak this time, David, or are you waiting
Again,
for
I'm
questions?
just here to field any questions if anybody has.
Do members have any questions of the speaker? Councillor Moxon.
Have a guess.
Hello again, my old friend. I'll let you ask you a question first, and then I'll come.
Same question
Same
again.
question.
Have you engaged with the local?
On this one, we haven't. So I presume your question following that might be why we haven't. So it seems a bit strange feedback, and so far on the applications that we've put through, we've done half as a consultant's approach and then half as none. There's initial feedback that we got from some members on initial application. Is basically we've had one separate to this in a similar area that has had a significant number of objections, and we fielded a 4-hour-long consultation evening from the afternoon to the evening to make sure everyone could come either in work or out of work. So it was a heavy night. It was a heavy night, but some of that feedback consisted of there was a huge kickoff, to be honest, because everybody didn't understand what its proposed use was for. So we basically gave them information on that. But a big part of that feedback was we actually told them, because they had a lot of concerns about what this was going to be, who was going to be in it, how it was going to be managed. And they were very apprehensive about a children's care home going into their area, because again, we do spend more on properties for nice areas because we are all a product of our environment, so we want the best environment for the kids. And they didn't know, but there'd been a children's home operating in their area for the last 8 years. When we put this consultation on, they had huge backlash and they didn't realise there was already a children's home there. And the feedback that we got from them is that, in their words, we're not bothered about that because we don't know it exists. So there's a very strong argument, and it's a learning curve for us as a business about which routes we do. And so far we've done half and half. Some people prefer ignorance is bliss, and they don't know that children's home is operating there because the whole point of it is it blends in like a normal family home and there shouldn't be any difference. Then absolutely, you've raised a very fair point, and sometimes the other argument for that is people armed with knowledge allays a lot of the fears. So it's a bit of a double-edged sword. So we've been doing 2 approaches to see which one's working best. So like I say, the previous one that we did, we held a community engagement event that was very well received. The community engagement event we did was half well received, half not well received, because it was just people who were not there to change people's minds, we're trying to fill them in with how we operate and procedures in place if they've ever got any issues, how they then come to us and approach it so we can resolve it. But again, 50% of that feedback was we're not bothered about that other home because we don't know about it, and so we're not concerned about it. So it's a case of sometimes do we ruffle feathers and actually go under the radar and use it as a normal house, home, so there's no prejudice against the child and the best environment to thrive in? Do we engage with the community, get buy-in from them, and allay their fears? So it's, to answer your question very succinctly, we've been doing both in engagement with the community, and then sometimes if it's a certificate, we've been blending with the
Members have any further questions? Councillor Tempest Mitchell.
Sorry. What's the average age of the child that would be in one of these homes?
the average age is 10 to 12 years old. We do take children from 7 to 17.
Thank you.
Any further questions? No indications? Thank you. Do members have any questions of the officers? No one's indicated. Thank you. I have a proposer for this application. Councillor Stevenson, Councillor Tempest Mitchell. In debate mode, does anyone want to make a comment? Councillor Moxon.
Yeah, I will just quickly say, I do think it's better to engage with local community first. I understand the developers. I understand where you're coming from. And it's about why you've not done it on this one. But in my experience, local residents tend to find out about them and complain, and there tends to be a frenzy sort of whipped up on without any basis, unfortunately. And I do think that if you try to engage with them, you're not going to please everyone. You genuinely not, but might allay some people's real horror fears that they've got about the place. So I would encourage you. I know it takes up a lot of your time, but I would encourage you to.
Any other comments? No one's indicated. Can I take this to a vote, please, with a show of hands to grant permission? Any abstentions? Any against? It's unanimous. New committee. So, planning application reference 2024-0166 full. Change of use from a 3-bedroom residential dwelling, use class C3, to a children's care home for 1 number vulnerable child C2, 54 Little Barn Lane, Mansfield. Granted permission with conditions. Thank you. Yeah. Can anyone vacating the meeting please leave so we can carry on? Thank you. Thank you. Right, I'll move on to item 7, which is plan application reference 2023-0630 COU change of use from a Class E to a Sui Generis adult gaming centre. I invite the officer to make the report, please.
Clarify the section of the Principle of Development, and in particular the weight given to policies RT1 and RT3. But does mention that these policies are out of date. However, just for clarification, this is only in respect of the reference to the use classes that are contained within this policy, these policies, not in respect of the principle per se. The principle of the policies is considered to be up to date and can be used for the assessment of this planning application in terms of the vitality and viability of the plan centre. Also, a further note to applicant is recommended to advise them that the development should be implemented in accordance with by design principle, in line with their submitted security and social responsibility statement. An application seeking planning permission to change the use of number 5 to 7 Stockwell Gate from Class B to a adult B. The application is for the principle of change of use only. No alterations proposed internally or externally. The application site is located within the Mansfield Town Centre shopping area identified by policy. There are 3 other ongoing applications, and 2 of them are seeking permission and listed building consent for shop front operations. Again, these are associated with the adult centre. This application has been referred to planning committee due to the number of objections that have been received. The application building is a grade 2 listed building and is located within the Bridge Street Conservation Area. There have been no statutory objections to the planning application, but there have been 6 letters of public objection which have been summarised in your report. Main considerations in respect to this application relate to the following. Firstly, the principle of development. Policy RT1's main town centre use town centres subject to criteria in compliance with RT3. Policy RT3 supports development for town centre uses subject to a number of thresholds, mostly limit the amount of non-class A1 region. Acknowledge that the use class A was revoked when the use classes were last updated. Most class A uses now come under class E, which incorporates a number of different uses in cafes, shops and offices and others. However, a gaming centre is considered so it is considered. Consider that this application is consistent with the overall principles of RT1 and RT3. which seek to ensure the vitality and viability of the town centre. The R23 specifically considers secondary. It is considered that the proposal is considered criteria A to D of the this analysis is pretty plus E. A1. 31 commercial unit relevant secondary front and 27 that's for each. Proposal is not 500. Maintains an active front. Therefore, consider the principles. In terms of amenity, it is not considered that the proposal would have a detrimental effect on residential needs in terms of noise or increase crime or highway safety and health. In conclusion, it is considered that the change of use site from class E and on the proposal would not result in any significant impacts in terms of the locality, the town centre. Recommendation is therefore to
Thank you for your report, Claire. Could I invite Harris Kasuji, the agent, to the podium? If you'd like to turn your mic on, Harris, and you've got 4 minutes. Speak.
Good afternoon, Chair.
Thank you.
This is an application for the principle of change of use only. We've worked separately with conservation to ensure that a traditional timber shop front is maintained at this site. There are no objections to the application, planning policy, conservation, or from the police. Planning applications must be determined in accordance with the development plan and any other relevant considerations. Proposal fully complies with the NPPF and the adopted development plan. There are no impacts on amenity. 87% of the relevant shopping, secondary shopping, will continue to be in class. And an active frontage will be maintained. Proposed use is a town centre use that one expects to find in town centre locations, and such uses are directed to be in town centre locations. The use will create 12 new jobs in the town centre and return to viable reuse a long-term vacant listed building. Therefore, respectfully request.
Thank you. Do members have any questions of the speaker? Councillor Hammersley.
Yeah, we said to go into bed.
Councillor Stevenson.
Thank you. So given that there's a casino next door that's also open 24 hours a day, is there a concern about the viability of the business and that this could end up being another empty shop in a year's time?
Admiral Casino, one of the largest adult gaming centre operators in the country, over 200 sites around the country. Most of them are very successful, they're very responsible operators, and their market research shows that this is a viable and a reason why it wouldn't be successful. These type of uses, they come. The applicant comes with a very, very good company, and they will ensure be there, and they'll create jobs in town.
Councillor Ellis.
Councillor Jackson, no, he's got the wrong half. My partner in the portfolio is Councillor Ellis, that's where that's come from. So some of the objections relate to negative social implications, antisocial behaviour, those sorts of things, which I imagine are generally associated with the use of alcohol. So does the centre have a policy or any contingency plans to manage people who may appear intoxicated, and to manage that sort of behaviour?
The premises operates on a think 20, no under 18. They're very, very highly regulated separately to the planning process. Also, license from, and these things are usually controlled by licensing regime rather than planning regime. So you get sort of two parts, but they're very, very highly regulated and yeah, but drunk.
Apologies, councillor Jackson. Any other questions? Councillor Hammersley.
I'm just a bit concerned about the residential use.
The applicant has control of the whole uses and they're empty. There won't be, there's actually no residential property in the area at all. I've been around, I've had a look everywhere in that entire street. There are no residential properties.
Any further questions? Unindicated. Thank you.
Thank you.
Members have any questions of the officers? No one's indicated. Thank you. Do I have a proposer and seconder this application? Councillor Stevenson, Councillor Jackson. In debate mode, anyone? Any councillors want to make comment? No comments? Thank you. Move to the vote then, please. All those in favour, please show. Those against? And any abstentions? Thank you very much. The application has been granted permission, 6 in favour, 2 against. It's planning application reference 2023-0630 COU, change of use from Class E to Sri Generous Adult Gaming Centre. Granted planning permission with conditions. Thank you. Thank you. We're now going to move on to item 8, which I requested come to the planning committee. As I already explained, I know the applicant and the objector, so I'm going to vacate the meeting and ask Vice Chairman Councillor Hammersley to come and take over.
Good evening, everyone. Application 2024-0118 HHA for 103 Sherwood Street, Warsaw. This is a retrospective application. First floor rear extension with balcony, a new porch to the front, a new roof with dormer to side and render finish. If I can hand over to the case officer, please.
Chair, please have. That, okay. Thank you. So, as was referenced, this application is a retrospective application. Just to note, most of the changes and all the external alterations in the description were already approved in some degree. So there's a slide that compares both schemes. So the original reference was 2020/0534/HHA. So that scheme was approved for similar description of alterations. So this application is retrospective, but broadly similar. The main difference is the design of those alterations, so predominantly towards the dormer. So this application was referred to plan committee by the chair. So as a reference, some of the alterations have already been approved. The elements that are new for this application include the remodeling of the roof, so principally dormer on the south-facing elevation, and there's new openings on the first and second floor levels. Dormer would be finished in charcoal grey, I think it's cladding. So there were two primary material considerations that are before the committee here, which is the impact of the proposal on the character and appearance of the area, and the potential impact of a proposal on residential amenity, both of the occupiers of the main dwelling itself, but also adjacent dwellings. So it's acknowledged that some of the alterations to the proposal would be visible from the street scene. Again, I think the main focus of this would be on the dormer extension. So as you can see in the photo there, the dormer is on towards the right hand side of the slide. So it's obviously it would be a feature which was different to what was previously approved. So it was originally a hip type design, which was slightly less intrusive than what is proposed here. However, it was the view of the officer that the impact on the character and appearance of the area wouldn't be unacceptable. Having visited the site, the dwelling is set roughly 11 meters back from the road. The actual visibility of it, the street scene, is therefore very minimal. And it would be subservient to the main dwelling, being, I think, this dropped ridge dwelling. So it wasn't considered that the overall unacceptable. Turning to the other consideration is residential amenity. So on the southern side elevation, so there would be two new obscure glazed windows at first floor level. On the same elevation at the second floor, there would be three new obscurely glazed windows. So of those windows, they would be obscurely glazed, but they would also be restricted with like a restrictive opener, so it wouldn't be possible to actually open the windows more than 100 millimeters. So someone could just swing the whole window door open and just overlook the garden of the closest adjacent property. So there's a condition on the decision notice to control that. The overall separation distance with the closest properties about 10 meters, and it wasn't considered that the impact in terms of overshadowing or overbearing development, it wasn't considered to be unacceptable. Obviously keeping in mind that some form of dormer extension had already been approved development. So subject to the conditions and the assessment in the report, it was recommended proposal wouldn't result in an unacceptable appearance or impact on the character appearance of the area or residential amenity. So it's recommended that permission is granted subject to the conditions outlined.
Thank you, Howard, for your detailed report. Can I invite Speaker Claire Cooper, please? Cooper. Is Claire Cooper here? If you could. Claire, you've got 4 minutes whenever you're ready, from whenever you're settled down. No rush.
Good evening. As stated, the original application was submitted to the council during lockdown. with no notices being sent to neighbouring properties, albeit properties owned by the applicant, the petrol station and George Street on the back. Neighbours on the south side, we were not informed, and because of the lockdown, there was no notice placed on the lamppost outside. Hence, the first application was approved with just conditions, and condition 4, I'm quite adamant about, that the windows on the south elevation should be non-opening with at least Pilkington 4 obscure glazing. The applicant, he started this development in December 2023, well within the 3-year time limit. It was soon obvious that the condition placed regarding the windows was not being adhered to. I contacted enforcement officer, not realizing that a whole scheme didn't adhere to the approved plans. Work has not started on the balcony, so I have no comments on that yet. But given the chance, I would have objected to the large balcony on the back of the property. The properties on the south side elevation, we have long private gardens, and we are losing this amenity which we've all had for at least 50 years. How can this committee be sure that the conditions placed on this application will be adhered to?
Yes, if you can leave it on. Any questions? Any questions to the Councillor Stevenson?
Thank you, Ms Cooper. I live on the Wicket, so I'm well aware of the development and what it looks like. Just wanted to clarify where exactly. Sorry, I just wanted to clarify where exactly you live in comparison to this. Is that next door?
Thank you. Take a question.
Thank you, and I can attest to the size of the development in regards to the dormer. It does appear to be very intrusive for neighbouring gardens, in my experience of living around the area. I just wanted to ask, what exactly impact has it had on your property and your enjoyment of that property?
Sorry. In the last couple of weeks, he has started working out again. What he's doing at the moment is putting blocks on the actual building, presumably to insulate it, and he's going round all his windows that are all opening, and which should have been in the original plan, you know, that were going to remain shut for the duration. This plan actually states that he's going to put restrictors on the window. But my question to you is, knowing his past form, is this ever going to happen? And if so, if it does go through with that proviso, how is it going to be enforced by the council? That's it, really. I can't, you know,
Thank you for explaining that.
say anything else.
Councillor Jackson.
Thank you. I could hear you very clearly. Thank
Yeah.
you. What I want to ask you is, these windows in the dormer, do they look down into your garden?
Yes.
Just so that I can get that in my
Yeah.
head.
I mean,
Okay.
okay, I'm 10 meters away
Yeah.
from those dormers. So the dormers are facing me.
Mhm.
You then got a driveway into the
Mhm.
whole property. You then got the width of the fish and chip shop.
Mhm.
But yes, the dormers are actually overlooking my property, 109, which at the moment is for sale.
Mhm.
And unfortunately, Kath Basie wasn't well enough to attend this meeting with me tonight at 111, but it affects all of us.
Okay.
And the balcony that he's proposing, which is the size of anybody's living room on the back of the premises, that is going to impact, but obviously until it's built, I
don't know.
don't know by how much.
Okay. Thank you very much. Thank you.
Thank you.
Thank you. Any further, Councillor Richard Tempest Mitchell.
Thanks, Chair. I think you said that you and other people have lived there for around 50 years. Is that right?
Sorry, I said,
How long have you lived there?
so I'm sorry,
How long have you lived on?
oh, I've lived in this property since 1973. I mean, I know a lot of people move on, and quite probably with what's happening around me now, I should have moved years ago. But yeah, it's a big property, 4-bedroom, detached, allegedly, big for one person. But one son's buggered off to New Zealand and left me with all his Star Wars figures, while the other one's buggered off to Tuxford and has still left all his junk in my house. Yeah, it would be nice to think I could downsize. I would like to do it, but at the moment, at 74 now, I'm getting to the stage where it's too much aggro.
Any further questions? Councillor Tempest Mitchell.
So I think what you're saying is you know the area very well.
Yes,
Do you think the building, if it was granted, would fit in with the surroundings?
it's affecting the gardens of all the 107, 109, 111, 113, without even going any further up the street. We've all got at least 170 foot of back garden, which has always been private.
Thank you. Okay.
I'm sorry, just to clarify, Councillor Jackson has basically said it's very large. So does the size of it fit in with the area where you live? So physically, the size of it, does it fit in?
No. Not with what's been built there in the past, no. Right.
Do we have any questions to the case officer, please? Councillor Moxon.
Thank you. How have we got to this situation where the applicants built a house that's completely different to what the plans were. Don't get that.
Just to clarify, I'm filling in the case. Yeah, the main case officer is ill tonight, so I'm filling in. I've not been at the council very long, so sorry if I don't know the detailed history. But so when you grant a planning permission for a development, you grant it generally subject to conditions, one of which is that it's undertaken in accordance with the approved plans. Most of the time that happens. At time to time, obviously someone will build out an applicant. Every reason, the exact reason for which could be numerous reasons why a development may not be undertaken in accordance with plans that have been submitted. I think generally, as a general sort of answer, it's not in itself a criminal offence to build something without planning permission, or to build something different from the plan proposed. So although this application is retrospective, so obviously we can only like planning's or enforcement's a reactive process. So when we get a complaint from a member of the public, our enforcement officer would have to go out and investigate an alleged breach of planning control, and based on an assessment of the site and the particular constraint, but then they could consider to take no formal action if it was really minor technical breach. They could proceed on informal action, or could recommend the planning application and submit it. So that's kind of why we've got to that basis. So the determination of that case would have been a retrospective application that was the most appropriate option at that time, and then that would come up development management process to deal with the application as submitted. That's matters. So we're assessing it on the planning considerations.
Yeah, thank you, Howard. That's very useful. If I can invite the Chief Planning Officer to comment. Thank you.
Yeah, just to add to that, clearly some developments do not always follow in terms of what was approved for various reasons. Sometimes it's minor alterations that some applicants don't deem worthy of notifying an authority. So it's not uncommon that such changes, some are more significant than others. I accept that, and this is quite significant. But clearly, as a planning authority, as any planning authority, to 700 applications, it's impossible to monitor on site every application, every development. No planning authority can do that. So obviously, do actually sometimes pick these up once the changes have been made, but hence pick this up in two choices. You have a build as per the plan, or you submit a retrospective application. They're the two choices that any applicant has. So that's where we are with this. So it does occasionally happen. The differences can be quite minimal, sometimes more significant.
Thank you, Martin. Any further questions from members to the case officer? Yeah, okay, Jack, thank you.
Chair, given and I'm aware that this applicant has a history of breaching planning applications that they put forward, are we in danger, or have we already set a precedent that this applicant can put whatever plans forward they wish, breach them, and we'll then approve whatever they build?
No, I would argue that that's not the case. We have to treat each application on its merits, even if it's retrospective, even if the applicant has a previous history of whatever, you still have to take face value on the plans before you. So yes, we can always enforce. Second time, third time, we will always enforce it.
Thank you. Just to clarify my first question, it wasn't a criticism, by the way, it was a genuine question of how we've got here. But anyway, separate point, the new dormer windows on so that's going to be the third floor, isn't it, basically? Did I hear right that there's a limit on how you're going to put a limit on how much they can open? My rudimentary understanding, so please tell me that I'm completely wrong. My rudimentary understanding of building regulations is that one of them would have to open fully, so it could be used as a fire escape, wouldn't it?
Building regulations obviously is separate legislation that they will have to comply with. If it doesn't, then obviously that would be a factor for building control to enforcement. We can't consider that dispute.
Any further questions? Councillor Tempest Mitchell.
Just to clarify that, so if we approve this, we'd be approving it with the conditions that the windows can't open, but actually we can't do that because planning regs would say that the window has to open. Does it make sense?
I think members have to bear in mind, I think maybe we did mention something, I can't remember now, but in terms of other legislation, we cannot be influenced by what others may do. And a good example of that is the licensing legislation. So whilst we may give for a public house, if licensing choose not to give it a license, liquor, whatever it is license, then they can't operate. But we're operating on different legislation, different criteria, different policies. And whilst others may not approve it, that shouldn't influence your decision at all. It's different legislation, and that's been held through the courts, etc.
Any further questions? If we can go into debate mode now, that would be good. Thank you. Any comments? Councillor Tempest Mitchell.
Just looking at it on here and on there and the size of it, and there's in the, sorry.
For that, I've just been advised. I've just been advised we need a proposer for the motion and a seconder for the, or not, for the recommendation from the officers. Can we have an alternative proposal? Stevenson.
Alternative proposal would be that the application is declined.
Do it for seconder, please. Councillor Bell. Can we have reasons for the refusal?
The application isn't encompassing what was agreed on the original plan.
Sorry, Councillor, if I can interject there, that would not be a bona fide reason for refusal. It's got to be the impacts of the development itself.
Yeah, to go further, the dormer is going to be impacting different properties.
So shall we say impact on residential amenity?
That sounds like a much better way of putting it. I appreciate that, Charles. As I say, it's not encompassing with the other developments or the area.
Character of the area.
Yes.
Yeah. Any further comments or reasons for refusal? Anyone? Yeah, Marty said that we need to refer to the local development policy, local plan policy.
To defend, an attempt to obviously defend a refusal, you need to have a policy background to that. So what is the relevant policy from the local plan?
Your advisors on that?
There is a policy on I can't remember, is it called housing extension? I haven't got the. Give me 1 second, I'll get that for you. Yeah, policies P6 and P7 relate to those issues. So if members want to refer to that, then that is their choice.
In that case, I think it would be wise to please. Actually, I'm not going to be able to put policies from the top of my head. I apologize.
Yeah, so the development is contrary to policy P6 and P7. Thank you, Martin. Yeah, I think councillor Bell seconded it, yeah. Refusal. Councillor Bell seconded. And we're going to debate mode, please. Any further comments from members of the committee? Can we put it to the vote? All those who support the new recommendation for refusal? It's unanimous, 6 in support of refusal. Thank you. Yep, therefore planning permission has been refused for application 2024-0118 HHA 103 Sherwood Street, Warsop, NG20 OJU. Thank you, members.
Thank you for that, Charles. I'll move on to agenda item 9, which is Human Rights Act. It's just for noting. Now a show of hands, please. Thank you. It's unanimous. Noted. Item 10. Appeal decisions received during the period. There have been none. That again is for noting. Can I have a show of hands to? Thank you. And final item, I believe, is item 11, which is the tree preservation order, land at Westgate House, 1 Chesterfield Road South, Mansfield, Notts. Can I ask the officer to make a report, please?
Thank you. Additional tree preservation order includes 1 copper beech tree and 2 lime trees located within the curtilage of Westgate House, Manchester. Original tree preservation order was served following the submission of a section 211 notice. 2 trees and work on trees. Council's tree officer has assessed the site and considers that these trees merit the protection of a trees add amenity value to the street scene. Photo shows the 2 lime trees from a distance on Chesterfield Road. Photo shows the 2 lime trees. So right here shows the copper beech tree to the front of Westgate House. For the reasons outlined in the report and presentation, it is recommended that members confirm the tree preservation.
For that report, do members have any questions of the officer? Do I have a proposer? Councillor Stevenson, Councillor Moxon, second. Debate mode, any comment? Nope. I move to a vote then with show of hands. All those in favour of granting this DPO? Any against? Any abstentions? Thank you. That's unanimous. So just confirm that tree preservation order, land at Westgate House, 1 Chesterfield Road South, Mansfield Notts, has been approved. Thank you. I believe that concludes tonight's agenda. Unless you'd like to stay behind for a question and answer session on the superb training session the planning officers gave us. I'd like to thank them for that, particularly the one on Teams that I attended, Charles. It was excellent. Just kidding. I don't think they really want to ask us any questions. So have a safe journey home. Thank you.